There is a photograph taken in a cotton mill in Lancaster, South Carolina, in November of 1908. A girl stands at a spinning frame that runs away down the room, far taller than she is, looking straight at the camera. The man who took it wrote a caption. He did not write down her age. He wrote down her height. 48 inches. 4 feet. Her name was Sadie Pfeiffer, and by that November she had been working there half a year. Nothing in that photograph was illegal. Not her age, not the 12-hour shift, not the machine she was reaching into. In 1908, no federal law in the United States said a child could not do that work. No minimum age, no maximum hours. No inspector who could walk in and stop it. So how did it end? And why did it take until the middle of the 20th century? When Congress finally passed a law in 1916, it stood for 9 months before the Supreme Court struck it down. And the man who brought the case that killed it was not a mill owner. He was a father, suing for the right to send his own 2 sons back into the mill. We are going to look at why a father would do that, at the photographer who lied his way into factories for 16 years, and at what happened to one of those boys 5 years after his father won. Let's open the vault. Start with the size of it, because the size is what people get wrong. This was not a handful of unlucky children in a few bad factories. In 1900, the United States Census counted 1,750,000 children between the ages of 10 and 15 who were working. That is more than 18% of all the children in that age band, roughly 1 in 5. That figure comes from the census itself and the Bureau of Labor Statistics, which has since published its own history of this period, puts it in the same place. It is not an activist's estimate. It is the government counting its own children at work. And that number is too low, for a simple reason. The census did not count children under 10. There were plenty of them, in the mills, in the canneries, on the streets. Historians who add them back get past 2 million, or about 21%. 1 American child in 5 at work. Where? Everywhere you can think of, and several places you cannot. Cotton mills across the Carolinas and Georgia. Coal breakers in Pennsylvania, where boys sat over moving chutes and picked slate out of the coal with their bare hands. Glass factories, where the heat ran all night and boys carried finished bottles from furnace to annealing oven. Canneries on the Gulf Coast, where 5-year-olds shucked oysters beside their mothers. Newsstands, telegraph offices, tobacco fields, seafood sheds, home workrooms, and New York tenements, where whole families made artificial flowers by lamplight. Look at one of those closely, because the detail is what makes it real. In the Pennsylvania coal breakers, boys as young as 8 or 9 sat on wooden boards straddling chutes of crushed coal moving beneath them, and picked out the slate and rock with bare hands, 10 hours a day, in air thick with coal dust. Their hands were cut open by the coal, so the skin hardened, and the older men called them by the state of their fingers. When a boy was big enough, he went down into the mine. When a miner was too broken to work underground anymore, he came back up and sat on the same boards beside the boys. And it was legal. All of it. Some states had laws. Most of those laws had holes you could drive a cart through. They applied only to certain industries, or they set the minimum age at 12, or they accepted a parent's word for a child's age with no document required. Enforcement, where it existed at all, was 1 inspector for an entire state. So the question is not why there was no federal law. The question is why anyone thought there should be one, in a country where this was simply how things had always been done. To understand that, you have to understand why the children were there in the first place. And the answer is not the one you expect. The comfortable version of this story has a villain, a mill owner with a cigar, dragging children out of schoolrooms to make himself rich. That version is wrong. And it is wrong in a way that matters, because it lets you off.
Look at the arithmetic of an actual family. A child in a cotton mill was paid, on average, 48 cents for a 12-hour day. Not an hour, a day. And a child was cheap, not because a mill owner was cruel, but because a child could not bargain, could not leave, and could be replaced by the next child in the mill village. The wage was low because the person earning it had no power at all. But here's the part that changes how you see it. The family needed the 48 cents. Children's wages made up as much as 20% of a working household's total income, $1.05. Take that away, and the family does not economize. The family stops eating. In 1909, a widow in Georgia worked in a mill with 5 of her 9 children. Together, 6 people, one of them a grown woman, 5 of them children, they earned $9 a week. Do the division. Then ask what happens to that household if the law says the 5 children have to stop. That is the trap, and everyone inside it knew it. The mill village made it tighter. The company owned the houses. The company owned the store. Wages were often paid partly in scrip that could only be spent at that store. A family that lost its children's wages did not just lose income, it could lose the roof, because the roof came with the job. There is a second pressure, quieter and just as strong. In a mill village, the whole family was one economic unit in the company's eyes. Hiring was done by household. A man might be taken on only if his wife and children came with him, because that is how the mill filled its frames. A father who kept his children out of the mill was not simply choosing to be poorer, he might be choosing to be unemployed. So when a reformer came to a mill town and said this must stop, the people he was trying to rescue very often told him to go away. Not because they liked it, because they had done the arithmetic, and he had not. You cannot ban a child's wage without replacing it. That is the sentence the entire fight turns on, and nobody in 1916 had an answer to it. There was no minimum wage for the father, no unemployment insurance, no relief, nothing that would put $1 back into that house, which means the reformers had to win the argument twice, once on cruelty, and once, much harder, on economics, against families who were living the numbers. They did not win the second one for another 22 years, but they nearly won the first one, and the reason they nearly won it was a schoolteacher with a camera. His name was Lewis Hine, and before any of this he was teaching botany and nature study at a school in New York. In 1908, the National Child Labor Committee hired him as an investigative photographer. He held that job for 16 years, until 1924, and in that time he did something that had never been done to an American industry before. He went inside and brought back pictures. That sounds simple. It was not, because Mills did not let him in. So he lied, repeatedly and with some flair. He turned up at factory gates as a Bible salesman, as a postcard salesman, as an insurance man, as a fire inspector. Sometimes he presented himself as an industrial photographer sent to document the machinery, which got him inside with a camera in his hands and a legitimate reason to point it at the factory floor. And once he was in, he worked fast. He photographed. He talked to the children while he did it. And he wrote down what they said on a card he kept hidden in his pocket, so no foreman would see him taking notes. That hidden card is what made the photographs into evidence, because a photograph on its own can be argued with. A mill owner could say the child was visiting, or was the janitor's daughter, or was 14 and small. Hine took that defense away. Beside each picture, he recorded the child's name, the age they gave, where their family came from, how many hours they worked, and what the work had done to them. The missing fingers, the coughs, the eyes. Names and ages, written down at the scene, next to a face. He was careful about the ages, because the ages were where the lying happened. A foreman would swear a child was 14. The child, asked quietly and away from the foreman, would say a different number, or say they did not know, or give the year they were born, and let Hine do the arithmetic. He noted which answer came from whom. That is why the captions read the way they do. the age the child gave, and beside it, sometimes, what the office claimed. The archive he left is enormous. The Library of Congress holds more than 5,100 prints and 355 glass negatives from that work. It is one of the most complete photographic records of any American injustice, and it exists because a man spent 16 years telling lies at factory doors. And it worked. Not immediately, and not completely, but it worked. The pictures went into magazines, into pamphlets, into exhibitions, into the hands of legislators. They were what turned an abstraction, child labor, a phrase, into a specific 10-year-old at a specific machine with a name. By 1916, Congress had finally moved. Here is the problem Congress had, and it is a legal problem, not a moral one. Congress could not simply ban child labor. Under the Constitution, as it was then understood, what happened inside a factory in North Carolina was North Carolina's business. The federal government had no general power to tell a state what age its citizens could start work. So Congress found a side door. It has the power to regulate commerce between states. Not manufacturing, commerce. So the law it wrote did not touch the factory at all. The Keating-Owen Act of 1916 said something narrower and cleverer. Goods made in a factory or mine that employed children under 14, or that worked children of 14 to 16 for more than 8 hours a day, could not be shipped across a state line. Make what you like. You just cannot sell it outside your own state. It was a workaround, and everybody knew it was a workaround. President Wilson signed it. For the first time in American history, there was a federal standard, a floor, applying to the whole country, saying that below a certain age, a child does not belong in a mill. The reformers had won. 20 years of investigation, photographs, hearings, and pamphlets had produced a law. The law was signed on the 1st of September, 1916. It did not come into effect for a full year after that, and it was in force for 9 months. The case that killed it came out of Charlotte, North Carolina, and it was brought by a man named Roland Dagenhart. Dagenhart worked at the Fidelity Manufacturing Company, a cotton mill. So did his 2 sons. Reuben was 15. John was 13. Under the new federal law, John could not work there at all, and Reuben could not work the hours he had been working. So Dagenhart went to federal court and asked for an injunction to stop the United States Attorney, a man named W.C. Hammer, from enforcing the law against the mill. Read the claim carefully, because it is the strangest sentence in this story. Dagenhart argued that Congress had violated his son's freedom to work. The father sued for the right to put his children back on the factory floor. Now, before you decide what you think of him, go back to the arithmetic in the second act. Roland Dagenhart was not a wealthy man making a point about federal power. He was a mill worker whose household budget had just lost 2 wages. Whether he was pushed into the case by the mill's lawyers, which is very likely, or brought it entirely of his own will, the underlying pressure was real, and it was the same pressure squeezing every family in that village. The case reached the Supreme Court in 1918. It was decided 5-4. Justice William R. Day wrote for the majority, and the reasoning came down to a single distinction. Congress may regulate commerce, but, Day wrote, the manufacture of goods is not commerce. Making a thing and shipping a thing are 2 different acts, and the federal power reaches only the second. Since Keating-Owen was aimed at the conditions of manufacture, it was outside the power of Congress, no matter what it said on its face. The law was struck down. The floor was gone. The dissent was written by Oliver Wendell Holmes, and it is short and cold and worth hearing in his own words. If there is any matter, he wrote, upon which civilized countries have agreed, far more unanimously than on drink and some other things this country is currently excited about,
It is the evil of premature and excessive child labor.
4 justices agreed with him. 5 did not. That was the whole margin. 1 vote, and 2 million children went back to where they had been. Congress did not accept it. Within a year it was back, and this time it came at the problem from a completely different direction. If the commerce power would not reach inside a factory, then perhaps the taxing power would. So in 1919, Congress passed the child labor tax. Any company that employed children below the line, under 14 in a mill, cannery, workshop, or factory, under 16 in a mine or quarry, would pay a tax of 10% of its entire net profit for the year. Not a fine, not an inspection regime, a tax. And look at how that was designed to work, because it is genuinely clever. Nobody was told what they could or could not do. A mill was perfectly free to employ 10-year-olds. It would simply hand over a tenth of everything it made that year for the privilege, which for any mill running on ordinary margins meant the practice stopped being worth it by lunchtime. Congress had found a second side door. The case against it came from a furniture company in North Carolina, the Drexel Furniture Company, and it reached the Supreme Court in 1922 as Bailey against Drexel Furniture. This time the court did not divide 5-4. It was 8-1. The opinion was written by the Chief Justice, William Howard Taft, who 10 years earlier had been President of the United States. His reasoning went to the heart of the trick. This, he said, is not a tax. A tax raises revenue. This levy was set at a rate calculated to make the conduct stop, and it applied only to those who knowingly did the thing Congress disapproved of. That makes it a penalty wearing a tax's clothes. And if Congress could do that, Taft went on, then there was no limit to it. Any subject a state controlled could be taken over by the federal government simply by attaching a tax to the behavior it wanted to end. The states would keep their authority on paper and lose it in fact. It is not a stupid argument. It is a serious one about where power stops. But the practical result was that in 4 years, Congress had tried twice and been beaten twice, and the margin had gone the wrong way. The first defeat was 1 vote. The second was 7. Whatever movement there had been on that bench, it was not in the direction of the children. That is where things stood in 1922. No federal law, no federal tax, 2 Supreme Court decisions saying the national government had no business in it at all, and 2 million children still working. And in the middle of that, a reporter went looking for a 20-year-old in Charlotte. 5 years later, in 1923, a reporter named Lowell Mellett went looking for the boys whose name was on that case. He found Reuben Dagenhart in Charlotte. Reuben was 20 years old. Mellett asked him the obvious question. You won. Your family won at the Supreme Court of the United States. What did you get out of it? I don't see that I got any benefit, Reuben said. I guess I'd been a lot better off if they hadn't won it. Then he described himself, and this is the part that is hard to hear. 105 pounds, he said, a grown man and no education. 105 pounds, 7.5 stone. That is the adult weight of a man who worked 12-hour shifts through the years his body was supposed to be growing. I may be mistaken, he went on, but I think the years I've put in the cotton mills have stunted my growth. They kept me from getting any schooling. He had left school after the 3rd grade. Sit with the shape of that for a second. A case is brought in a boy's name on the argument that the law was taking away his freedom. The case wins at the highest court in the country, and the boy keeps his freedom to work. And 5 years later, the boy is a man of 20 who weighs 105 pounds, cannot read well, and says out loud that he wishes his side had lost. The person the freedom belonged to did not want it. That interview ran in 1923, and its timing mattered because the reformers had not given up. They had simply concluded that if the Supreme Court would not let Congress do this, then the Constitution itself would have to be changed. In 1924, Congress passed a constitutional amendment, giving itself the power to regulate the labor of persons under 18. The votes were not close.
The House passed it on the 26th of April, 297 to 69. The Senate passed it on the 2nd of June, 61 to 23. Both far beyond the two-thirds required. Then it went to the states, where 3/4 of them, 36, had to ratify it. It never got there. A few states ratified in 1924 and 1925, and then it simply stopped. What stopped it was an organized opposition campaign, and the arguments it used are worth knowing because they are not the arguments you would guess. Manufacturers funded it, obviously, but the public case was not made about profits. It was made about families. Opponents argued the amendment would let the federal government reach into the home and tell parents what their own children could do, that a boy could not be made to do chores on his father's farm, that the state was taking over the raising of children. And this was the early 1920s, so the second argument was inevitable. The amendment was denounced as socialist, a Bolshevik idea imported into American law in the middle of the Red Scare. The proposal to stop children working 12-hour shifts was successfully sold to the public as an attack on the family. By 1937, only 28 states had ratified, 8 short. The amendment never took effect, and, because Congress attached no deadline to it, it is technically still pending to this day. What finally ended it was not the amendment and not the courts. It was the Depression. When adults could not find work, the argument for keeping children out of jobs stopped being only about children. In 1938, Congress passed the Fair Labor Standards Act, which set a federal minimum wage, a maximum working week, and, quietly, in the same law, federal limits on child labor. 3 years after that, in 1941, the Supreme Court took up the question again in United States v. Darby and overruled Hammer v. Dagenhart outright. Justice Harlan Fiske Stone wrote that the 1918 decision had been a novelty, unsupported, a departure, and was exhausted as precedent. The court adopted Holmes's dissent as the law. 23 years after Roland Dagenhart won, his victory was erased. 22 years passed between the first federal law and the one that stuck. Count what that cost in the only unit that matters. A child who was 10 in 1916, the year the first law passed, was 32 by the time the law that worked came into force. The whole of that person's childhood and youth happened in the gap. Notice also who never got compensated. There is no fund, no settlement, no apology for the generation that worked those years. The reform arrived, and the people it arrived too late for simply carried the difference for the rest of their lives, in their lungs, in their hands, in what they could and could not read. Reuben Dagenhart was around 35 when the Fair Labor Standards Act passed. The law that would have kept him in school arrived a full generation after the schooling was gone. And notice what actually closed that gap. Not a change of heart, not the photographs, though the photographs made it visible, not the amendment, which failed. What closed it was the moment the country found a way to make the family whole without the child's wage, a minimum wage for the adult in the same act on the same day. The reformers had needed to win 2 arguments. The cruelty argument they won in about 1910 with a camera. The arithmetic argument they could not win until 1938, and they won it not by proving the child's wage was wrong, but by finally replacing it. Rights are cheap when somebody else pays for them. So my question to you is this: what is being tolerated right now in plain sight, not because people think it is good, but because a household somewhere cannot afford for it to stop? Tell me in the comments. I read them. And the next time you see one of those photographs, Sadie Pfeiffer at her spinning frame, measured in inches because nobody would vouch for her years, remember that the argument against them was not that they were happy. Nobody claimed that. The argument was that their families needed the money, and for 22 years that argument won. If you want more of these, the parts of ordinary life that turn out to have a start date, subscribe and open the vault with us. There is another one waiting for you right here.